Obviously, we encourage that all children attend the shelter care hearing. It's the first opportunity for you to meet your client. A lot of folks don't know how to make that happen, and the agency has custody of the child, so if you make a request to your agency, I have not yet had a case where they've refused to make a child available. Shelter care hearings are the first time that a child's going to see the court, and it's often a very frightening experience, and they often leave not knowing anything more than they came in with. So there's a number of things that I encourage you to ask for at the shelter care hearing. The orders that come out of a shelter care hearing are expected to contain findings. It is not enough for the shelter care order to simply state that shelter care is warranted and schedule the next hearing date. A shelter care order should set forth times for visitation between siblings and with the guardian from whom the children were removed. It should address whether the current placement is appropriate for the child, whether it's least restrictive, and why. If it will disrupt the child's school, it should address whether the child's continuing medical needs are being addressed, if there were current appointments that were scheduled that need to be maintained. That's something that should come up at a shelter care hearing. The most important thing you can do that you can take away from shelter is to make sure you ask questions. Even if you don't know the answer, and even if you know the caseworker is not going to know the answer, you still need to ask the question. Does the child have all of their things? Do they have the clothes that they need to be able to get to school? If the homecoming dance is coming up, do they have their dress and their shoes? When it comes to the visitation question, past practice has always been that when the child says to us, "When am I going to get to see mom?" we say to them, "Soon." And what soon sounds like to a child who's frightened and doesn't understand what's happening is never. And we need to remedy that. So instead of saying soon, you need to ask the court and make a proposed solution. Let it be Tuesday. Give them something that they can, concrete, that they can look at and know is going to happen, and it's something for them to look forward to. We all know that more frequent visitation with families encourages reunification to happen sooner. So take that opportunity at the shelter care hearing and ask the question. There's a lot of debate about supervised and unsupervised visitation, where visitation can happen, does it have to happen at the agency or not? This is a real opportunity to use your common sense and ask those questions. For example, a child that is removed from a home for home conditions doesn't necessarily warrant supervision if there were no safety concerns about the child and the parent. So that visitation might not need to be supervised. If it's not supervised, that parent might be able to see that child 2 or 3, 4 times a week, as opposed to once every 2 weeks for 2 hours. So although at a shelter hearing you don't have all the information that you could want, it doesn't mean that you can't ask questions and really put everybody thinking on their feet and come up with as good of a solution as you can pending the next hearing.
It's my privilege to talk to you as guardians ad litem and the importance of your role from a judicial perspective. From the moment you are appointed to represent a child, your focus should be upon developing the relationship with that child that you represent. And the first thing you should do is obtain all the information you can from the caseworker, that file, and from any references in that file to other individuals. The importance of the pre-hearing preparation cannot be overemphasized. If you have difficulty in obtaining information, do not be afraid to request that the judge become involved in requiring the release of information to you, because you cannot begin to effectively represent that child until you are first informed. Once you are informed with a record review, you should begin the development of the relationship with the child. That requires a meeting, many meetings in advance of the hearing where you will be representing that child's interest. You should be in touch with the caseworker at all times regarding if any possible change in the location for the child, and you should freely give your information to both the child and any foster parent or guardian responsible for that child. That means your name, your telephone number, your address, and also where you can be reached when that child may be available, which may mean evening work. That's part of the responsibility of a guardian ad litem. You should not be meeting the child for the first time in the few minutes before the hearing. That does not allow for the development of the relationship. When you come to court in representing the child, and now you have the relationship and all the information, you should be an active participant in that entire process. Think about the questions you want to ask in advance by way of cross-examination. The worst thing you can do is say, no questions. I can't tell you the times I've been disappointed in hearing a witness present testimony, and I anxiously await for that guardian ad litem to challenge areas of testimony, and I get the response, no questions, Your Honor. That means you've not been prepared and are not ready to represent that child. After the hearing in the case, you must continue your representation. That's required by rules, and it's required for effective representation. That means staying in touch with the caseworker, evaluating the progress towards the goals that have been set in the hearing. That's how you effectively represent the child. Do not be afraid to question processes that are followed by your individual counties. Don't accept the answer, well, that's the way we always do it. Because if we don't question the processes, there will never be effective change, and that's our responsibility. You must be sure that you keep the focus on the child and your responsibility for representing the interests of that child throughout the hearing. I fully recognize the difficulty this presents to active practitioners and appreciate your willingness to sacrifice on a professional level to represent children. You should take full advantage of all trainings that are offered through OCYF, become involved on a statewide basis in knowing others in your shoes in other counties, because we may learn best from others who are practicing in other areas of this Commonwealth. Stay up to date on all the current law that affects your area of work. I've provided you with the do's, what I expect of you, but I also want to just provide a very short list of don'ts. And really they are just the converse statement of some of the things I have been saying. The first should be very obvious to you. Don't get in this work for the money. We all know you are not well paid in terms of dollars, but I can't tell you the satisfaction that you will experience until you fully represent a child to the best of your ability and see the difference you can make in the life of a child. Another don't is don't wait for information to come to you. Rather, you be the proactive one, seeking the information, prodding the caseworker, prodding the parents, prodding the child, to make certain that all the plans that have been laid out in a plan are well on their way to completion well before the hearing that is scheduled, hopefully a minimum of 3 months from the last time you're in court. And that leads to another one. Don't just accept the fact that you are given a very short period of time in court to represent the interests of your child. Advocate for sufficient time for you to present your case, your evidence, and fully represent the child's interest. Do not regularly ask that the child be excused from the proceedings. That should be the exception rather than the rule. It's very important that the judge has an opportunity to see the individual child about whom everyone is talking and about whom decisions are made. That may require you to be a little innovative. Have your little tools with you for entertaining a preschool child, a school-age child, and even a recalcitrant teenager who really does not want to be present in the courtroom. I do not mind at all if there are crayons and paper, if there's just a pen and a pad, something for that child to be engaged in and maybe feeling a little more comfortable by looking like they're not fully involved, but they're listening to what's happening. I do not want to end on the don'ts, but rather go back to the do's. Everything that I have talked about, I hope will inspire you to form the relationship with the child that you represent. And thank you for the work that you do.
With respect to the guardian ad litems, the child advocate attorneys, they should talk to their young clients before they get to court. They should ask their client questions. They should make sure their client asks questions to promote their conversation before they get into court, so that they don't have to stop in the middle of the court proceeding and say, let me talk to my client for a few minutes. Making the client feel stressed or confused or uncertain about what's going on, what questions they could or should ask. They should talk to their young client about the prospect of talking to the judge if they want to, that's an option for them. If a child wants to speak, they should be given the right to speak. Quite frankly, no matter how young or old they are. For me, as juvenile court judge, that's sometimes a game changer when I hear from the young client of the guardian ad litem. If I hear from a child, if you have trouble contacting the child, contact the OCY caseworker. If the caseworker, for some reason, is unable to be reached, contact the supervisor. Make sure you talk to your client before court. Make sure you ask them what they want to see happen in court. Ask them if they want to say something, what is it they want to say. They may have trouble with the way they want to say what they want to say. Without leading them or suggesting things to them, do a little practice Q&A to reduce the jitters and prepare them. If you can, bring them into the courtroom before court so that they can get a comfort level of what's going on. And I'm talking about kids as young as 4, 5, 6, however little they are, or even the oldest of teenagers, 16, 17, 18. They're all nervous. Start with that assumption. Explain to your clients who they're going to see in the courtroom. Explain the dynamic of the dependency proceeding. Who are the litigants? Who are you going to see? Who should you expect to see? What's going to unfold? What's going to happen? What are the possibilities of what are going to happen? This goes for the children and the parents. You need to give them an idea, a prediction, so to speak, without giving them a guarantee. Make sure you explain to your client each proceeding and the meaning of each proceeding and what's going to happen. Shelter care proceeding is very different than an adjudication and a disposition. And it's very important for a child or a parent to understand the nature of the proceedings and what could happen at each step. Ask your clients if they have questions. Many times, I know myself as an attorney, albeit now I'm a judge, but I remember quite well, I found myself often just talking to the witness. You have to remember to stop and ask them if they have questions. Be mindful that the judge may ask questions also, and you want to be prepared, not to look good, but to be representing your client as a professional, so that your client feels good and confident, and that all other parties have confidence in the other professionals in the system, and so that the judge sees that everybody is prepared and professional.